This week we saw Twitter do something that we don't often see tech companies do. They decided to fight the court on behalf of one of their users. Now, the user in question is Malcolm Harris. He was one of hundreds of people who were arrested on the Brooklyn Bridge during an Occupy Wall Street march last October. Now, many of the protesters arrested decided to make deals with the prosecution, but not Harris, who issued a plea of not guilty. Then the prosecution decided that in order to make a case against Harris, they would need his tweets from the time surrounding that march. So they sent a subpoena to Twitter asking for all of Harris's tweets from mid-September 2011 through the new year. Now, we're going to get into the latest details in Harris's case in just a second, but to fully understand the elements at play here, we've got to take a quick stroll down Twitter's subpoena history, because this is far from the first time that Twitter has actually taken a stand for its users. See, back in May of 2010, Pennsylvania Attorney General Tom Corbett wanted to know the names of two anonymous Twitter users who, let's just say, weren't his biggest fans. Now, Corbett had a grand jury subpoena Twitter for the users' real identities, and Twitter fought that court order, coming to the defense of their users. Then, in December that same year, Twitter received another subpoena. This time, it was the U.S. government looking for the personal information, including addresses of users like Jacob Applebaum, Bradley Manning, and Julian Assange. Now, the subpoena came with a gag order that prevented Twitter from notifying the users in question. But a month later, in January 2011, Twitter won a fight to have that subpoena unsealed so that they could notify the users, so that the users could actually challenge the release of their personal information in court. Now, let's fast forward to 2012. As I told you earlier, Malcolm Harris has decided to fight his disorderly conduct charge in court, and the prosecution has issued a subpoena to Twitter for his tweets. Now, Twitter informed Malcolm of the subpoena, and when it's become business as usual, Malcolm and his lawyers are fighting the release. But last month, a judge ruled that Malcolm could not fight that subpoena because it wasn't issued to him, but to Twitter. So now we get to the landmark moment. Yesterday it was announced that Twitter would be fighting the release of Malcolm's tweets. They're going to court to fight for Malcolm's right to defend his own privacy. In a statement, Ben Lee, Twitter's legal counsel, said Twitter's terms of service make absolutely clear that its users own their content. Our filing with the court reaffirms our steadfast commitment to defending those rights for our users. But it's obviously not practical for every company to go out to court to protect every single user that the government wants to get information on. So we have to ask what this really means for the future of privacy, the internet, and the way that prosecution handles technology. Joining me to discuss it is Malcolm Harris, senior editor of The New Inquiry. Malcolm, thanks for joining us tonight. And I guess for starters, how does it feel to have a big tech giant defending you?
Well, it certainly makes me feel a little safer than I did when they were being noticeably quiet earlier in the proceedings. I guess they had to wait to see how the first round went before stepping in. But it's nice to have that giant blue bird at my back.
I mean, do you wish that, that more big companies out there were to do this? Because, if the trend says anything, it seems like people like yourself are often, left with no tools when it comes to trying to fight orders like this, fight subpoenas like this in court. So is it going to be up to the Twitters, the Googles of the world?
Yeah, in a lot of ways. I mean, if this had been another social media service, there's a good chance I never would have heard about the subpoena until they started reading my tweets aloud in court. If it had been Facebook or Google, I don't know how it would have gone. Luckily, Twitter has been a little more dependable in that realm than some of its competitors.
But then, of course, like I just said, if this is something that becomes the norm, all the tech giants aren't going to start going out and defending every single one of their users. So ultimately, what is it that you think needs to happen, that needs to change? One of the arguments that the judge makes here is that this isn't a violation of your privacy because it's out there, it's on the internet. This isn't your personal private home. You don't have a home online. But what's your take?
Well, I'm neither a lawyer nor a judge, but I think the brief that Twitter's counsel filed makes a very strong argument that the judge's earlier ruling is not the way that the law should stand, and that it would present a really impossible burden on them as a company. If other companies face a sort of similar situation where they have to answer every subpoena, it seems they're either going to take the Twitter path and argue that the user should be able to challenge them themselves, or just comply with every subpoena without worrying about it, which I think is a really dangerous situation for users.
Why do you think that they're really going after you and spending so much time doing this in this case, right? Obviously, hundreds of other people were arrested that day in Brooklyn on that bridge. They said yes and, and took a deal, but you said no, but they're spending a lot of time just trying to get your tweets. Do you think that there's some intimidation factor involved?
Well, I really can't speculate as to the motives of the Manhattan District Attorney's Office. It's hard to know what's going on in their heads. But it seems to me that this is an attempt to set a precedent for the kind of policing of political activists in the United States we're going to see in the coming months and years. So this is going to be a real test case, and I'm glad it's going the way it is right now.
Well, yeah, I mean, what do you think in terms of the direction that it's heading when it comes to our ability to go out and protest here in this country, right? Not only have we really seen a massive clampdown by police when it comes to the Occupy movement in the last 6 months, but just at the top of the show, I was talking about this ordinance that was passed in North Carolina, preparing for the DNC, where suddenly having a marker is something that can get you arrested.
Yeah, I think in the United States, we're going to see the policing of anti-capitalist protesters go the way we've already seen it in England, where social media has played a role, where if you post the wrong thing on your Facebook about what you did the other day, you might end up in jail for a year. And I think we've already started to see that. We saw that in Cleveland with the FBI manufacturing a bomb plot against so-called anarchists. And these are the sort of tactics they've used to manufacture terror plots in the past. And I think we're going to see more and more of that as the sort of Occupy sequence heats up.
But do you think that at least, people might be able to outsmart the authorities in a certain sense? I enjoyed the fact that Twitter did argue in court that it could have saved everyone a lot of time and a lot of money if they would have just downloaded or saved your tweets originally before it became too late to find them online.
Yeah, no, I think we definitely have a knowledge advantage when it comes to understanding how these technologies work. You can tell from the prosecutor's filings and the positions they've taken in this case that there's not a real strong understanding in the DA's office of how Twitter actually works. They compared it to bank records. And if I'm an account holder in a bank, I can't go in and just change all my account details, which I'm able to do with Twitter. So I think we do have a step on them in that way.
Yeah, well, I think that's something we're seeing not only in the courts, but in Congress, too, when it comes to certain legislation that deals with new technologies. But, Malcolm, thanks for joining us tonight, and we'll definitely be following your case.
Thanks so much for having me.